Hi, I'm Jordan Isringhouse, the Chief Legal Officer of Swift Law North. I'm here today with Aaron Swift, CEO of Swift Law North. And today we want to talk about some of the new Regulation F standards for collection calls, texts, etc., in relation to the FDCPA. So, Aaron, to kind of start at the top level of the topic, I want to ask you kind of why new regulations? Where are we at with the world in debt collection?
That's a great question, and I'm going to give you a little bit of a history lesson for Jordan and our audience. So the FDCPA law we've been talking about in this introductory base series is a federal law that covers debt collection. And in the congressional record, when they talk about the reasons why it's needed, in the original history, it talks about because too many people are interrupting dinner to get phone calls on your home line. Well, how often does that happen now? Also, welcome to our mascot. This is Finn. He's our Consumer Law 101 and Swift Law North mascot. So if you see him in and out videos, don't pay him any mind. He's all good. So anyway, so just to put into some historical context of why new regulations is the world has changed. The internet didn't exist in 1977 when this law was changed. Cell phones didn't exist. So with the changing times of debt collection methods like cell phones and all, using social media to debt collect. These weren't even figments of someone's imagination when this law started and was passed, 4+ decades ago. So it was time. And just recently, the last several years, Congress said we need to add more into this law, new protections for consumers and new rules and regulations for the collectors.
Okay, so with those new rules, new regulations, the new guardrails for these debt collectors, what are kind of maybe 3 to 4 of the most common violations that you will see from these new I guess you'd anticipate from these new regulations?
Yeah, good question. So let's talk about the 3 to 4 most biggest changes and how those can be violated, because that's probably the best way to answer. So one of the things that the new Reg F standards put in is a call cap. Debt collectors, most famous for collection calls. That's the most annoying thing, especially now that we mostly all carry cell phones in our pocket. You can be reached at any time, day or night, while you're in the restroom, while you're making dinner, while you're putting your kids to sleep. So one of the things that this new regulation changed is how many calls can be placed at any one given time. Before, it was the Wild West. You had one court in one state saying it's more than one call a day is harassing. Another court saying, no, you need to call them at least 10 times a day to harassing, or 100 times a month, and so on and so forth. And because it's a federal law, we wanted to standardize it. So what the new regulation said is you can only call someone up to 7 times in 1 week. So think about that. That's one a day. And if you connect, then you can't call that person for another 7-day cycle. Those are 2 brand new rules that didn't exist before. So the landscape has really changed. Before, collectors basically said, I have free license to call as many times or a very high number, and I can call them back-to-back days multiple times in one day even. Now you can't. So if that happens, if a collector calls you more than 7 times in a week or more than 1 time in a day, or a consumer gets called once and answers and they're called again before the next 6 days transpires, then you have an FDCPA violation. So that's one of the new changes and how that applies to the FDCPA protections.
Well, I know some people don't even, like you said, people don't even answer their phones anymore. So, and definitely less and less people answer their phones. Probably more people, if they're on their phone, probably looking at social media, probably looking at other stuff. How does it relate to that? Where's it head with that world?
Again, great question, because you go back to when this law was originally passed. Social media didn't exist. So this law, this new regulation, does put some safeguards into place for social media, which I'll talk about, and text messages. People are now getting debt collection text messages. And one of the things that this new law, the new regulations require, is you have to give someone an opt-out from text messages. So if a debt collector is hounding you, you have to get one of those, reply stop to opt out. Or, we all see those things when we get a message from a company that maybe we don't recognize as debt collectors have to give you a way out. They can't just have free access to text you at any given time with no recourse. So if that happens, that's also a violation. And then you mentioned social media. This is truly the wild, wild west. It is a new paradigm with debt collectors making up Facebook profiles and then finding you, sending you a direct message or a direct message on Twitter or even LinkedIn.
You mean X, right?
Yes, excuse me, X.
Okay.
Now, these new protections, they put into place safeguards to make sure it's not truly public. So like a debt collector cannot go on your, actually I don't even think Facebook walls exist anymore, but can't put something on your Facebook public facing that says, you owe me money. Or they can't write on your X or Twitter feed or wall, hey, you need to pay me. If they're going to contact you via social media, it has to be via a private way, like a direct message or a Facebook message direct to you. And you still have to have an opportunity to opt out in those instances as well.
Anything else that debt collectors have to tell you? I think there's like some sort of disclosures they might have to give you now or something. There were already some.
That's right. That's right. And as we talked about in an earlier video, some of the things that debt collectors can and must do. And if they don't, they can be common violations. And you're exactly right. When a debt collector comes on the scene, they have to give you certain information. They have to disclose who they are, why you're hearing from someone new, how much you owe. And these new regulations even give you more information. How you can opt out, how you can talk to them. They even require in some states to be written in Spanish as well. Because here in Florida, there's a lot of Spanish-speaking consumers. Now some debt collection notices have to be sent in Spanish, which all good protections. And just think about these new regulations because of changing times, because of changing technology. So we can reach people easier through text messaging, through social media, the use of call dialing technology. You get those annoying calls and it's a machine on the other line. A machine can place 1 billion calls in a month. In 1977, there wasn't a debt collection company who could place 1 billion calls in 50 years. So with the changing times came changing new rules and regulations, and that's what we're talking about.
So how would you tie in some of these new regulations, new protections to consumers with credit reporting? I mean, does it dovetail with that?
It does a little bit, and also just debt collection in general. So it's a great question. So first of all, the regulations don't specifically detail any new rules or regulations as it relates to credit reporting, but some of the new model disclosure notices will help you as the consumer to check your credit report. So if a debt collector sends you a letter, they have to use some model language and model information now, which includes more than before. And so now you'll have more information to compare and contrast against your credit report to figure out, do I owe this or what do I owe? So yeah, that's a great question. And again, all of this ties back into these new regulations are now a part of the FDCPA, just like it would have been if it had passed originally. So you can add these types of protections on the kind of the repertoire of what the consumer can use to protect him or herself, or what our affiliate partners can use in conjunction with us lawyers to hold them accountable. Because breaking any of these new Reg F violations, it's just like breaking the old FDCPA. The consumer can sue, they can get money in their pocket, they can stop the harassment and not pay out of pocket for the fees and costs.
Okay, well, thank you, Aaron. I think you've put a good bow on the idea of how to use these regulations and to empower the consumer and empower, obviously, all our affiliates, consumers to protect themselves and make sure that if there's debt collection going on, at least it's by the book. So we thank you to our affiliates, and if you have any questions, please continue to move forward in the lecture series, and we'll probably answer a lot of your questions. But of course, the attorneys at Swift Law North are always here should you have other concerns and questions. Thank you.
Thank you.